How you doing?
Exhausted. Good morning. Committee will please come to order. Quorum being present. Committee meets today pursuant to notice to consider H.R. 2694, the Pregnant Workers Fairness Act. And I note in the audience the gentleman from New York, Mr. Nadler, and H.R. 5191, the Runaway and Homeless Youth and Trafficking Prevention Act of 2019. Chair announces that any requests for recorded votes may be rolled pursuant to Clause 2 of Rule 9 of the Rules of the House and Committee Rules 13B. Pursuant to House Rule 11, Clause 1, the Chair may recess the committee at any point. I now recognize myself for an opening statement. Today, the committee is considering two bills, H.R. 2694, the Pregnant Workers Fairness Act, and H.R. 5191, the Runaway and Homeless Youth and Trafficking Prevention Act of 2019. The first bill, the Pregnant Workers Fairness Act, was introduced by the gentleman from New York, Mr. Nadler, and Representative Cato, is a bipartisan proposal to guarantee basic workplace protection for pregnant women. Women increasingly become the primary breadwinners of American households, and so a growing number of pregnant workers are working later in their pregnancies. Recent data indicate that more than 80% of first-time mothers worked into their last trimester. Unfortunately, far too many pregnant workers do not have access to reasonable accommodations to protect their health and safety and the health of their babies. These accommodations, which can include water, seating, more frequent restroom breaks, or even temporary lifting restrictions, are not complex or costly, but without basic protections, pregnant women can be forced to endure significant potentially tragic health risks. These risks impact many working women, but tend to disproportionately affect Black and Latino workers who are overrepresented in low-wage, physically demanding jobs. In 2015, the Supreme Court's landmark decision, Young v. UPS, allowed pregnant workers to bring reasonable accommodation claims under the Pregnancy Discrimination Act. Unfortunately, pregnant workers are still being denied accommodations because the Young decision set an unreasonably high standard for proving discrimination. Under the Young decision, the pregnant worker must show that the employer provided accommodations to her coworkers who were similar in their inability to work. That standard is onerous in part because it assumes workers have access to personnel information about their coworkers and their accommodation requests and were able to establish a comparable group. As a result, in approximately 2/3 of the cases after Young, courts ruled against the pregnant workers who are seeking accommodations. The bill before us guarantees pregnant workers a basic right to seek an accommodation that will allow them to continue working without jeopardizing their health or pregnancy. Pregnant Workers Fairness Act, like the Americans with Disabilities Act, requires pregnant workers and their employers to negotiate and agree to a reasonable accommodation that is not unduly burdened to the employer. The bill grants workers alleging pregnancy discrimination the same remedies available to employees alleging discrimination on the basis of race, color, religion, sex, or national origin under Title VII of the Civil Rights Act of 1964. The Pregnant Workers Fairness Act is a bipartisan solution supported by worker and employer advocates, including the U.S. Chamber of Commerce, A Better Balance, and the National Women's Law Center, and many others. I want to thank those groups for their diligent efforts and thoughtful input to advance the bill, and all of those groups agree on the version of the bill that will be presented in the amendment in nature of a substitute. And I ask unanimous consent to introduce letters of support for the amendment in nature of a substitute from those groups. That amendment in nature substitute is not the bill that any one group would have proposed, but it is one that all can agree on. In times of division in the nation, this is an example of what can happen when diverse groups work together, and I would urge all of our members to accept this bipartisan compromise without amendment that could unravel the compromise. Second bill before us, the Runaway and Homeless Youth and Trafficking Prevention Act, is a reauthorization of the 1974 Runaway and Homeless Youth Act, which remains a critical tool in supporting youth who lack stable housing. More than 4 million teens and adults experience homelessness each year as a result of family instability, parent rejection, or financial hardship. For many of these young people, homelessness will shape the trajectory of the rest of their lives. Without stable housing, young Americans cannot access resources often needed to excel in school, avoid abuse or sexual exploitation, and live self-sufficient and rewarding lives. The challenge of homelessness is disproportionately felt by individuals who suffer from systemic discrimination. LGBTQ and children of color are far more likely to experience homelessness than their peers. In fact, researchers have found that 20% of homeless youth population identifies as LGBTQ, with rates reaching as high as 40% in some communities across the country. Although existing programs funded through the Runaway and Homeless Youth Act provide critical services to homeless youth across the country, federal services just reach a fraction of the millions of teens and young adults without permanent homes. It has been more than a decade since Congress reauthorized the bill, and bipartisan reauthorization under consideration today makes critical improvements and will empower states to strengthen and expand services for young people. In addition to increasing funding for federal youth and homeless programs, the proposal puts greater focus on trauma-informed services and more emphasis on reaching and adequately supporting vulnerable homeless youth, including those who have experienced sexual or human trafficking, and it ensures that federal programs for homeless youth do not discriminate on the basis of race, color, religion, national origin, sex, gender identity, sexual orientation, or disability. Notably, the anti-discrimination provisions in this legislation codify existing programmatic regulations and are identical to the language in the Violence Against Women Act, which passed the House on a bipartisan basis in 2013 with the support of at least 87 Republicans. Given the Trump administration has begun to dismantle HHS-wide anti-discrimination regulations, it is imperative that this committee move to codify non-discrimination language for the Runaway and Homeless Youth Program and protect the thousands of LGBTQ youth seeking shelter and services through these programs. In sum, the bill will improve the quality and accessibility of critical programs that serve homeless youth, and I want to thank Representatives Yarmouth, Bacon, Jayapal, and Hayes for working across the aisle in this important issue, and I urge all of my colleagues to support the legislation. So I urge members of the committee to support the bipartisan proposals before us today and yield to the ranking member, Dr. Fox, for the purpose of an opening statement.
Thank you, Mr. Chairman. Today we're marking up two bills, the Pregnant Workers Fairness Act, H.R. 2694, and the Runaway and Homeless Youth Act, H.R. 5191. The first is an example of bipartisan negotiations, and I want to express my appreciation for Chairman Scott's willingness to work together. Disappointingly, on the second, we were denied the opportunity to engage in bipartisan negotiations to improve the bill. Regarding H.R. 2694, committee Republicans have long been committed to policies that empower all Americans to achieve success. Discrimination of any kind should not be tolerated, and no one should ever be denied an opportunity because of unlawful discrimination. That is why there are important protections under federal law to prevent workplace discrimination, including federal laws that protect pregnant workers. Republicans in Congress have long supported meaningful and clearly defined protections for pregnant workers that ensure they are not being unlawfully discriminated against as it relates to pregnancy, childbirth, or related medical conditions. Significant progress has been made negotiating a bipartisan compromise on H.R. 2694, and I commend Chairman Scott for his willingness to entertain these discussions. Unfortunately, one major issue remains. The legislation we will consider could result in religious organizations being denied protections they receive under current law. I plan to address this issue in greater detail during the markup and look forward to continuing efforts to build on the progress that's been made to date and to secure a bipartisan compromise on H.R. 2694. Now I'll turn to the other bill we'll discuss today, Runaway and Homeless Youth and Trafficking Prevention Act of 2019. Our children are this country's most valuable asset. Unfortunately, they are also the most vulnerable in our society. For homeless and runaway youth, there are devastating dangers and risks that can compromise their safety and health. Sadly, reports indicate that in the United States, around 700,000 youth are without homes. As lawmakers, we must help protect American youth from the dangers homelessness presents. In 2018, Congress enacted a short reauthorization of Runaway and Homeless Youth Act to continue to provide services to runaway and homeless youth, including outreach and education for sexual abuse or trafficking victims. Committee Republicans support a longer authorization of these important programs now. Unfortunately, committee Republicans were denied an opportunity to engage in bipartisan discussions to address the failings of the Democrat legislation before us today that reauthorizes these important programs. The Democrats' bill promises funding levels they know will never be reached during the life of the reauthorization. The bill also fails to include important accountability measures. That's why we'll offer an amendment that updates RIA to better address issues runaway and homeless youth face, with a specific focus on helping youth harmed by sexual exploitation and substance use disorder. Specifically, our legislative language will better help youth harmed by sexual exploitation and substance use disorder, require grantees to follow non-discrimination laws, and protect taxpayer dollars from waste, fraud, and abuse. I look forward to further discussing both H.R. 2694 and H.R. 5191, including the common sense solutions Republican members will offer. I yield back, Mr. Chairman.
Thank you. Without objection, all members who wish to insert written opening statements to the record may do so by submitting them to the committee clerk electronically by the end of the day today. House rules require a copy of measures be made available to members and public at least 24 hours in advance, and that was done. The first reading of the bill will first take up H.R. 2694, first reading. Clerk will read the title of the bill.
H.R. 2694, to eliminate discrimination and promote women's health and economic security by ensuring reasonable workplace accommodations for workers' ability to perform the functions of a job are limited by pregnancy, childbirth, or a related medical condition.
Thank you. The committee will now proceed with the consideration of H.R. 2694 for amendment. The bill was circulated in advance. Printed copies are available. And so the clerk will designated the bill. Without objection, the first reading, the bill will be dispensed with. And the second reading of the bill for amendment, without objection, the bill will be considered as read and open for amendment at any point. Any amendment offered shall be considered as read. I now recognize myself for the purpose of offering an amendment in the nature of a substitute. The clerk will designate the amendment in the nature of a substitute.
Amendment in the nature of a substitute to H.R. 2694, offered by Mr. Scott of Virginia.
Without objection, the amendment shall be considered original text and open to amendment at any point. The amendment in nature of a substitute has already been distributed and is in each of your folders. I'll now recognize myself for 5 minutes to explain the amendment in the nature of a substitute. The ANS incorporates a number of changes that are a result of a good faith negotiation process between the majority and minority committee staff over the last couple of months. This amendment in nature of a substitute is responsive to many of the concerns raised by minority witnesses during the October 22nd legislative hearing of the Civil Rights and Human Services Subcommittee, and reflects input received from numerous organizations, including advocates for pregnant workers, civil rights groups, and the U.S. Chamber of Commerce. First, the ANF clarifies that an employer cannot require a qualified employee to accept an accommodation other than one established through employer-employee interaction process, a process which has also been used under the Americans with Disabilities Act to arrive at a reasonable accommodation. Second, the ANS adds an employer defense. Under this provision, employers would not be liable for damages if the employer demonstrates good faith efforts and negotiations with the employee during the interactive process to identify and make reasonable accommodations that would provide an employee with an equally effective opportunity and would not cause an undue hardship on the operation of the covered entity. Third, the H.R. 2694, as introduced, did not define key terms. The ANS more clearly defines these terms It clarifies that the term employer is one who has 15 or more employees. It adds a definition of who would be considered a qualified employee by incorporating key elements from the Americans with Disabilities Act. Qualified employee includes a job applicant who, with or without reasonable accommodations, can perform the essential functions of the job. The employee is still considered a qualified employee if the inability to perform an essential job function is temporary. The ANS defines the term known limitations. A known limitation means a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that the pregnant worker or her representative has communicated to the employer. Fourth and finally, the ANS adds a severability clause clarifying that if any provision is held invalid or found unconstitutional, the remainder of the act shall not be affected. This compromise has the support of the U.S. Chamber of Commerce and groups representing workers, including A Better Balance, the National Women's Law Center, American Civil Liberties Union, and the National Partnership for Women and Families, just to name a few. I want to recognize exceptional work by these groups to reach common ground with each other in the committee. As I noted earlier, it's regrettable that the ranking member is choosing to forego the carefully considered bipartisan agreement, but I want to read from a letter, January 13th, 2020, signed by Better Balance, the National Partnership for Women and Families, the National Women's Law Center, the ACLU, and the U.S. Chamber of Commerce, which goes through the points of the bill but concludes that with the manager's amendment, this is a strong bill and a reminder that through good faith negotiations, legislative solutions to important questions and problems can be found. We strongly believe that the manager's amendment deserves to be approved with no changes. So I urge a yes vote on the amendment of the nature substitute, no vote on subsequent amendments, and a yes vote on final passage. Are there others that wish to speak to the amendment in the nature of a substitute? Gentleman from Tennessee.
Thank you, Mr. Chairman. As an OBGYN specialist who practiced medicine for over 31 years, the issue of pregnancy is one I take very seriously and upon which I built a career before coming to Congress. Given the important nature of this issue and my years of experience caring for pregnant women, I appreciate the committee's consideration of this legislation today. And just into the real world, I was trying to think this morning when we were getting ready to start the meeting, and all the years that I practiced, had I really ever had a time when I felt like that one of my patients needed not to work or to be limited? Was that limited? And I could not remember a time when I said, this patient needs to stop work or stop lifting or whatever, that an employer defined that. I don't remember a single time that's happened. My fellow Republicans and I support protections in federal law for pregnant workers, and we believe employers should provide reasonable accommodations as well. We support the provisions contained in the Chairman's ANS and appreciate the bipartisan negotiations that took place to get this bill where it is today. While there's still work to be done, we commend the Chairman for improvements to H.R. 2694. H.R. 2694, as introduced, did not require a pregnant worker, in order to be eligible for an accommodation, to be able to perform the essential functions of the job with a reasonable accommodation. This is a sensible provision now included in the bill. A definition of, quotes, known limitation, end quotes, related to pregnancy, childbirth, or related medical conditions was also initially excluded, but the bill now includes such a definition, including a requirement that employees communicate the known limitation to the employer. This provision will help the workers and their employers understand their rights and responsibilities. Accordingly, the original draft of H.R. 2694 appeared to allow employees a unilateral veto over offered accommodations, but the bill now clarifies that reasonable accommodations will typically be determined through a balanced and interactive dialogue between workers and employers, like the process implemented under the Americans with Disabilities Act. It also did not include a limitation on applicability to employers with 15 or more employees, as is the case in Title VII of the Civil Rights Act and Title I of the Americans with Disabilities Act, but now includes the 15-employee threshold. Finally, the bill now includes a provision that if an employer makes a good faith effort to determine a reasonable accommodation through the interactive process with the employer is not liable for damages. Unfortunately, despite agreement on these changes, there remains an important outstanding issue that needs to be resolved. There is a narrow but long-standing provision from the Civil Rights Act that is not currently incorporated in H.R. 2694 that protects religious organizations from being forced to make employment decisions that conflict with their faith. The First Amendment guarantees all Americans the freedom of religion, and for over 240 years, Supreme Court decisions and laws written by Congress have maintained strong protections for religious liberty. Excluding such a provision in this bill could lead to confusion and even a constitutional challenge. We should be mindful of protecting religious liberty and maintaining a protection in this bill like those found in other similar laws. And I guess the question I have, Mr. Chairman, is where there's one set of laws in the Civil Rights Act that conflict with this current legislation, where do we go? How is that resolved? And I think we should avoid that confusion if we could. Mr. Chairman, we've made good progress, I would say great progress to date, negotiating a bipartisan compromise on H.R. 2694, and I look forward to working towards securing a bipartisan agreement on this legislation with you before the bill is considered by the whole House. And with that, I yield back.
Thank you. Others wish to speak to the amendment? Gentlelady from Oregon.
Thank you, Mr. Chairman. I move to strike the last word.
Ladies recognized.
Thank you, Mr. Chairman. I want to start by welcoming to the markup the Chair of the Judiciary Committee, Representative Nadler. I know Representative Nadler, who was the author of the Pregnant Workers Fairness Act, has been working on this issue for many years, so we're glad you're here today. Pregnant workers should not have to choose between a healthy pregnancy and financial stability. As both a mom and a policymaker, I am so glad that we're advancing a bill that was already bipartisan when it came to this committee and continues to be bipartisan to combat pregnancy discrimination in the workplace. According to A Better Balance, their representative came and testified at the subcommittee hearing, 75% of women will be pregnant while employed at some time in their life, yet more than 4 decades after passage of the Pregnancy Discrimination Act, federal law is not preventing discrimination because it does not require that pregnant workers have access to reasonable workplace accommodations. Pregnant workers may need a reasonable accommodation like seating or water, light duty, something that will help protect their health and the health of their baby. And when pregnant workers do not have access to the accommodations they need, they are at risk of losing their job, being denied a promotion, or not being hired in the first place. Unfortunately, a pregnant woman today can continue to suffer workplace discrimination at an alarming rate. According to a recent survey from the National Partnership for Women and Families, more than 60% of women have experienced some sort of pregnancy discrimination on the job. Now, my home state of Oregon is helping to lead the way on protections for pregnant workers. Last year, the state legislature passed a bipartisan bill to require employers to provide reasonable accommodations to applicants or employees with known limitations related to pregnancy, childbirth, or related medical condition, unless it would impose an undue hardship. Now, I have to say that the results have been very positive. Pregnant women have welcomed the accommodations, and the business community has welcomed the certainty. But we need to make sure that all pregnant workers, regardless of where they live, can access the protections they need to stay in the workplace. And I want to add that before I chaired the Civil Rights and Human Services Subcommittee hearing on pregnancy discrimination last October, I spoke with some of our state leaders, including our state labor commissioner, about how the bill is working in Oregon. It has been very positively received, especially, as I mentioned, from the business community. They like that certainty of knowing what they need to do to accommodate. Many members of the business community were very pleased to find out that an accommodation can often cost nothing, just making arrangements that help accommodate that pregnant woman. So we heard very compelling testimony in our subcommittee hearing from witnesses who established that far too many pregnant workers are denied access to reasonable workplace accommodations despite federal law providing for equal treatment on the job. So this bipartisan Pregnant Workers Fairness Act is our opportunity to address pregnancy discrimination in a meaningful way and to protect the health, well-being, and economic security of all pregnant and parenting workers and their families. By clarifying the right of pregnant workers to fair treatment in the workplace, we will finally guarantee pregnant workers the accommodations they need without facing discrimination or retaliation. I urge my colleagues to support this amendment in the nature of the substitute, and I want to thank the chairman and the staff for working so hard between the subcommittee hearing and today to reach this amendment in the nature of the substitute. I encourage everyone to support it, and I yield back the balance of my time.
Thank you. Others wish to speak? Gentleman from Michigan.
Thank you, Mr. Chairman. I move to strike the last word. Pregnancy discrimination is a real issue that requires congressional action to fix. I firmly agree with that. This is an issue I've been working on, in fact, for the past 5 years, and would like to see a solution for all pregnant workers across America. My Pregnancy Discrimination Amendment Act is a solution that would work towards a goal I believe we all share, legislating appropriate accommodations for pregnant workers. My legislation modernizes the Pregnancy Discrimination Act, PDA, of 1978, by clarifying that a pregnant worker in a similar ability or inability to perform a duty due to a pregnancy shall be treated the same as non-pregnant workers in terms of accommodation. This common sense solution removes any ambiguity in the law to ensure expecting mothers can continue to count on these protections. My bill empowers working women, promotes workplace flexibility, and protects against discrimination and unequal treatment in the workplace. It also goes along with the Civil Rights Act. Unfortunately, H.R. 2694, the bill before us today, while having significant improvements, has been mentioned already with our chairman's ANS, still infringes upon religious liberties, First Amendment constitutional liberties, and instead of borrowing from the Civil Rights Act of 1964, the legislation encroaches upon religious institutions' rights. I commend Dr. Fox for her tireless efforts in working to identify bipartisan solutions to this serious issue. And we've come a ways, but not as far as we could or should. Mr. Chairman, I believe we can do better in identifying solutions we all can support on such important issues. And I hope we can continue to work together on this important issue in a bipartisan manner on behalf of the rights of pregnant workers and their constitutional liberties. I yield back.
Thank you. The others wish to speak? Gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chairman. I move to strike the last word.
Ladies recognized for 5 minutes.
Mr. Chairman, I speak in support of the amendment in the nature of a substitute to H.R. 2694, the Pregnant Women's Fairness Act. Over 40 years since the Pregnancy Discrimination Act was first enacted, providing civil rights protections to pregnant women, it's shameful that we're still trying to address this issue today. Every year, roughly 250,000 women in America are denied basic accommodations to continue their work once pregnant. This discrimination can take many forms. Some pose a mere inconvenience to the mother, but others can have deadly consequences. And of course, these burdens fall particularly hard on women of color, who are overrepresented in many of the low-wage jobs that are either physically demanding, lack adequate workforce protections, or both. One of the key reasons why I co-founded with my colleague from Illinois, the Black Maternal Health Caucus, with Representative Lauren Underwood. So I'm pleased that the committee has taken a step today to address an aspect of a crisis that claims the lives of Black women 3 to 4 times more often than white women. Today we send the message that nowhere on earth should a woman have to worry about her health or the health of her pregnancy because her employer refuses to oblige her reasonable needs for accommodation. In essence, we tell millions of young women that no longer will pregnancy prevent you from taking your dreams as far as they can take you. I yield back, Mr. Chair.
Thank you, gentlelady. Yields back. Does others wish to speak to the amendment? Gentlelady from Washington.
Mr. Chairman, I move to strike the last word.
Ladies recognized for 5 minutes.
Thank you, Mr. Chairman, for your excellent work on this amendment in the nature of a substitute, and I too want to thank Chairman Nadler for his long dedication to this issue and for bringing this bill forward. I'm proud to say that my home state of Washington is one of 27 states that has already adopted legislation to protect pregnant workers fairly. We in the Pacific Northwest, along with Oregon, understand what needs to be done, and we get it done. Since 2017, pregnant workers in Washington have been entitled to reasonable accommodations that include additional bathroom breaks. All of us who have been pregnant understand how important that is, modifications to workplace food and drink policies, the provision of seating as needed, and lifting restrictions. Pregnant workers are also entitled to a range of additional accommodations as needed, which allows pregnant workers in Washington to stay healthy. And that is something that's essential for our children, for our families, and for our healthcare system. This wasn't always the case. Before our state's protections went into effect, the nation's largest ambulance service provider in the country denied a hardworking pregnant EMT in Spokane, Washington, some very basic accommodations during her third trimester, even though other non-pregnant employees were given the very same accommodations. It shouldn't be that you have to live in one of these 27 states in the Pacific Northwest, though we welcome everyone who wants to come in. It shouldn't be that you have to live in these states in order to get these protections. They should be available to pregnant workers everywhere across the country. In a hearing we held earlier this year, we heard from an Alabama EMT who faced the exact same treatment as the Spokane, Washington EMT. She too should have a law protecting her. We know that many workers are working far later into their pregnancies than ever before, and we know that many pregnant workers need their employer to provide them with basic accommodations that allow them to perform their jobs successfully while also protecting their health. It's especially important that we provide accommodations for workers in demanding physical jobs like nursing, retail, food service, and house cleaning. The most common accommodation that workers request is a stool. Just a stool. These kinds of simple, reasonable accommodations ensure that pregnant workers can work safely. When workers get accommodations, their health is better protected, and the workplace is more fair since pregnant workers aren't forced out of the workplace when they could work should they choose to. The Pregnant Workers Fairness Act keeps families from losing critical income they need. It diminishes job-related stress that can lead to low birth weight and is likely to address one of the causes behind the gender wage gap. It is also crucial that this legislation apply to all pregnant workers, as Chairman Scott's bill does. Pregnant workers must be protected in all workplaces, no exceptions. Now, to be clear, the legislation doesn't replace the need for federal paid family leave. Pregnant workers should be able to work if they wish and be able to take paid leave when they need to. Once again, our great state of Washington began providing for paid family leave in 2019, and we're beginning to see the many benefits to workers. Those benefits include higher rates of employer retention of women workers, and higher labor force participation by women, higher workplace productivity, and more utilization of crucial preventive medical care. As one Washington employer who has been both a pregnant and working mom put it, as an employer, I strove to provide my staff with the benefits, the treatment, and the human decency and respect that I didn't experience myself as a young parent, and it was well worth it. I couldn't agree more. It is well worth it to make sure that pregnant workers are treated with fairness and respect, and that's what Chairman Nadler's bill and Chairman Scott's amendment in the nature of a substitute does. I urge my colleagues to support. Thank you. I yield back.
Thank you. The others wish to speak on the amendment? Gentlelady from Pennsylvania.
Thank you, Chairman Scott. I move to strike the last word.
Ladies recognized for 5 minutes.
Thank you. Even the healthiest pregnancies have symptoms that may necessitate a reasonable accommodation at work. Fatigue, nausea, vomiting, and frequent urination, back pain are more than just nuisances. These are symptoms that can make it impossible to work without reasonable accommodation. Often there are unexpected side effects. In my own case, I had severe kidney stones at 8 months, requiring me to take frequent breaks to deal with the pain until I had dealt with the kidney stones. Accommodations can make pregnant workers' lives a bit easier, allow workers to continue to earn before going on maternity leave, and can ensure that productivity does not slip. In a country where paid maternity leave is not codified in law, and we are working tirelessly on rectifying that glaring omission, the least we can do is to pass a bill that forbids employers from forcing pregnant workers out of the workforce. The National Women's Law Center, in partnership with other advocacy groups, studied this issue at length. The stories were alarming. This bill is for the security worker who was denied a stool to sit on, for the retail worker being denied an accommodation that she lift no more than 20 pounds, for the letter carrier who was denied a modified schedule when summer days got unsafely hot, and for the food service worker who was denied more frequent bathroom breaks. But this bill is so much more. It is also for the workers with known limitations related to childbirth, because we recognize that mental health conditions like postpartum depression are real and tangible medical conditions, just like any physical condition associated with childbirth. Today, we recognize that postpartum depression deserves reasonable accommodation and deserves protection from workplace discrimination. Being able to provide for your child is more than just receiving a biweekly paycheck. It's about work-life balance, a healthy environment for child and for mother. It is possible for the workplace to provide that balance for workers without undue hardship being placed on an employer. Unfortunately, under current law, a pregnant worker must show that other non-pregnant employees are similarly accommodated in order to secure an accommodation, a standard that is far harder to meet than the reasonableness one applied in disability discrimination cases. Because the challenges of pregnancy are so unique, it is difficult to find comparable instances where non-pregnant workers received similar accommodation. That difficulty is reflected in the court statistics. Courts have ruled against pregnant workers in 2/3 of cases since Young versus UPS established a comparator test. I thank leadership for marking up this bill to fix the accommodation standard for pregnant workers. And I thank both the ACLU and the Chamber of Commerce for endorsing this bill. I urge a yes vote, and I yield back the balance of my time.
Thank you. The gentlelady from Florida, Ms. Shalala.
Thank you, Mr. Chairman, and I want to thank Chairman Nadler as well. I move to strike the last word.
Gentlelady's recognized.
I strongly support the Pregnant Workers Fairness Act, and I'm proud to be a co-sponsor and that the bill has bipartisan support. This legislation standardizes and clarifies the process to allow pregnant workers to keep working during their pregnancy. Current law has proven both inadequate to protect pregnant workers from discrimination and cumbersome for employers to administer. I appreciate the committee has come together in a bipartisan fashion to fix this problem. Just last week, the Department of Labor statistics showed that only for the second time in our history have women outnumbered men in the United States paid workforce. Inevitably, some of these women will become pregnant, and some of these women will need reasonable accommodations, like breaks for water or less lifting, to ensure that they have a safe, healthy pregnancy and are able to support their families during their pregnancy. The current situation is not working for anyone, but it's especially not working for those who have more physically demanding jobs and those in low-wage jobs. Allowing pregnant workers to have a reasonable accommodation, a term and practice that employers are very familiar with under the Americans with Disabilities Act, is a clear solution to this problem. Reasonable accommodations, including simple things like bathroom breaks, a different parking spot, appropriately sized work clothing, and safety apparel, or being excused from strenuous activity or heavy lifting. Already, at least half of the states and 5 cities have enacted laws like the Pregnant Workers Fairness Act. It's time for the federal government to do the same. We should not have pregnant workers losing their jobs because they need to use the restroom more often or need to have a water bottle with them on the retail floor, or because for a few months of their employment, they're not able to lift above a certain amount. I strongly support this legislation. I appreciate the committee's hard work on this issue, and I'd urge all of my colleagues to support the ANS. Thank you, Mr. Chairman. I yield back.
Thank you. The others wish to speak to the amendment. Gentlelady from Georgia.
Thank you, Mr. Chairman. I move to strike the last word. I want to thank Chairman Nadler, who I have the benefit of being able to work with on Judiciary Committee, and I want to thank Representative Katko, Representative Butler, and Chairman Scott. Thank you so much for bringing forth this legislation for markup and the hard work that every one of you have put into making this a bipartisan piece of legislation. I'm proud to be an original co-sponsor of the Pregnant Workers Fairness Act. No woman should ever have to choose between maintaining a healthy pregnancy and her paycheck. Unfortunately, current law provides no clear protections for pregnant workers, and that is unacceptable. Without accommodations, pregnant workers can experience serious complications. Having been a flight attendant for 30 years, I know exactly what I'm talking about. I have firsthand experience with the consequences lacking safety measures for pregnant women. I continued to fly while I was pregnant as a flight attendant. However, I had 3 miscarriages and ended up having a fetal demise. And when I became pregnant with my son, Jordan, my doctor, my specialist, demanded that I stayed home. And I was placed on short-term disability for that time. Really for the entire pregnancy. Flight attendants throughout my entire career were still expected to come to work, to push and pull heavy beverage and meal carts that weighed anywhere between 175 and over 200 pounds. We were still expected, if there was an emergency, to open and close extremely heavy aircraft doors. We were still expected to help passengers lift and put their bags in the overhead bins, and flight attendants were still expected to carry and lift their own luggage. I know the importance of passing this legislation. Most flight attendants that I worked with, because they could not afford to take off the entire time for their pregnancies, worked well to the end of their second trimesters, risking the health of not only their lives, but their unborn children. No woman should ever have to go through that, and no woman would under this legislation. The Pregnant Workers Fairness Act will ensure that the health of our women and babies does not come at the expense of their economic security. This issue is especially pressing for low-income women, many of whom work on their feet in physically demanding jobs and cannot afford to lose their wages. 27 states have already passed laws that require certain employers to provide accommodations to pregnant women. It is time for federal action that guarantees all pregnant women are protected from discrimination. This legislation is an important step in protecting pregnant mothers from discrimination. The Pregnant Workers Fairness Act will provide a clear framework for both workers and employers, and I am hopeful that it reduces the cases of discrimination. We still have a very, very long way to go, but this legislation is a step towards the right direction and a more just and fair and equitable workplace for women. And I yield back the balance of my time.
Anyone else wish to speak to the amendment? Gentlelady from Florida.
Thank you, Mr. Chair. I'm pleased that we're taking up H.R. 2694, the Pregnant Workers Fairness Act, in our committee today. I'm a proud co-sponsor, and I support its intent and the seriousness of this issue. According to the Centers for Disease Control, there are nearly 4 million births in this country per year. These are CDC statistics. Many, if not most, pregnant women must work during some portion of the pregnancy. Certainly, most of the mothers in this room worked during some portion of their pregnancy. It just happens to be a fact of modern life. This bill will clarify that reasonable accommodations should be made that will enable expectant mothers to continue to work safely. Accommodations may be as simple as providing a sitting stool, a change in work schedule, or restricting the amount of weight that the expectant mother lifts. This bill ensures that both employers and employees have clarity about who is entitled to reasonable accommodations and how to determine what those reasonable accommodations may be. This is a common sense approach to an issue that impacts every American family. It will help families avoid the devastating financial impacts of losing income at a critical moment of need. I'm pleased to support this bill because I believe that no one should be forced to choose between a healthy pregnancy and a job. I yield back the balance of my time.
Thank you. Are there others who wish to speak to the amendment? Gentlelady from Connecticut.
Mr. Chair, I move to strike the last word.
Gentlelady is recognized.
Women across Connecticut have experienced pregnancy discrimination on the job for years. Since 2011, 492 formal complaints of pregnancy-related discrimination, 302 of which were complaints about being fired, have been filed with the State Commission on Human Rights and Opportunities. In 2013, veteran Connecticut firefighter Regina Skates was placed on an unrequested, unpaid maternity leave. Despite the department's unlimited sick and injury paid leave policy, Skates was reprimanded for taking days off due to morning sickness, only permitted 30 days of administrative duty, then forced into taking her FMLA when her plans were to work another 2 months. She returned to work 2 weeks after she exhausted her leave. After failing to settle with the city, she sued for violations of her rights under Title VII of the Civil Rights Act. In 2018, 6 low-wage Black women suffered miscarriages while working at warehouses operated by XPO Logistics, a company headquartered in Connecticut, even after asking for reasonable accommodations and providing notes from their doctors. Thanks to work by advocates like A Better Balance, reporting by the New York Times, and intervention by members of Congress, XPO introduced a new pregnancy policy seemingly designed to prevent tragedies such as these. But 6 miscarriages due to unsafe working conditions is 6 too many. Connecticut passed a pregnancy discrimination law in 2017 that strengthened protections for pregnant workers. Stakeholders from both sides of the aisle, including companies like Cigna, have supported this bill to safeguard pregnant employees and provide stability and clarity for employers. Under the Pregnant Workers Fairness Act, employers will not have to worry about complying with the patchwork of state laws and risking lengthy, costly litigation. Employee morale, retention, and productivity will increase, and the number of workers receiving public assistance will decrease. Every reasonable accommodation denied puts a pregnancy needlessly in peril. Every worker forced into unpaid, unrequested family leave is thrown into financial insecurity. Every check lost further exacerbates the wage gap and financial discrimination women endure every day due to persistent gender biases. I urge my colleagues to support this amendment in the nature of a substitute. And with that, I yield back.
Gentlelady yields back. The others wish to speak to the amendment? If not, there being no further discussion on the amendment nature of a substitute, committee will now move to consideration of amendments. Does any member wish to offer an amendment?
Mr. Chairman,
Gentlelady from North Carolina.
I have an amendment at the desk.
Clerk will report the amendment.
Substitute amendment in the nature of a substitute to H.R. 2694, offered by Ms. Fox of North Carolina.
Mr. Chairman,
Gentlelady from Connecticut.
I reserve a point of order.
Point of order is reserved. Gentlelady from North Carolina is recognized on behalf of her amendment.
Thank you, Mr. Chairman. Mr. Chairman, Republicans support protections in federal law for pregnant workers, and we believe employers should provide reasonable accommodations for pregnant workers. We're supportive of the provisions contained in the chairman's amendment in the nature of a substitute, which were outlined by Representative Rowe. We're also appreciative of the negotiations that took place over the past couple of months, and we commend the chairman for the improvements to H.R. 2694 that have been made to date. Unfortunately, despite our agreement on these changes, there remains an important outstanding issue which needs to be resolved. The bill should include a narrow but long-standing provision from the Civil Rights Act that is not currently incorporated in H.R. 2694, which protects religious organizations from being forced to make employment decisions that conflict with their faith. This very limited provision is already in current law and allows religious organizations to make religiously based employment decisions. By not including this longstanding Civil Rights Act provision, H.R. 2694 could create legal risk for religious organizations in their religiously based employment decisions. In fact, a Democrat-invited witness at the hearing on H.R. 2694 highlighted Kentucky's recently enacted pregnancy accommodation law as a template for Congress to follow. Kentucky's law includes a religious organization protection very similar to the one found in the Civil Rights Act. At least 16 states in the District of Columbia in their pregnancy discrimination or pregnancy accommodation laws also include a provision similar to the Civil Rights Act religious organization protection. By adding a simple reference in H.R. 2694 to the Civil Rights Act, we can harmonize the bill and current law and ensure that religious organizations receive the same protections they already have in the Civil Rights Act. To sum up, my amendment includes Chairman Scott's A&S in its entirety, with one important addition relating to religious organizations' protections. My amendment simply incorporates the Title VII religious organization protection to ensure these organizations are not forced to violate their faith in making employment and accommodation decisions. If my amendment is adopted, I'd be able to support the chairman's amendment in the nature of a substitute. I yield back.
Thank you. I recognize myself in opposition to the amendment and strongly oppose the amendment. This amendment in the nature of a substitute. The Pregnant Workers Fairness Act is about ensuring that pregnant workers can stay safe and healthy on the job by being provided reasonable accommodations for pregnancy, childbirth, or related medical conditions unless those accommodations are an undue burden to the employer. This amendment would jeopardize women's health and risk their pregnancies, as it would provide a religious exemption to the requirement to provide basic and reasonable accommodations. Pregnancy accommodation legislation, including the Pregnant Workers Fairness Act, has broad support across the political spectrum at both the federal and state levels, and broad bipartisan support from members of Congress. And why? That's because we know that when women are denied accommodations, they face increased health risks, including premature births, pregnancy complications, and even miscarriage. We also know that when women are denied accommodations, they're put in an impossible position of choosing between a paycheck and their own health in pregnancy. You know that most of the time these accommodations are at no cost or minimal cost to the employer. The amendment before us seeks to insert a religious exemption for religious employers so that they do not have to provide accommodations to their workers' pregnancy-related conditions. But the fact is that religious employers can already make a claim under the Religious Freedom Restoration Act if a required accommodation is a substantial undue burden to their exercise of religion. Therefore, the amendment is not necessary. The amendment also injects controversy. It is a solution in search of a problem and undermines the carefully balanced agreements that are reflected in this legislation. Now, some of us take the position that RFRA has already erroneously been used to undermine non-discrimination provisions, and we could have gone so far as to carve out RFRA from this legislation so that it wouldn't apply at all. But instead, we kept the bill neutral with respect to RFRA claims in order to maintain its broad bipartisan support. We did this to avoid the obstacle of achieving real progress for women's health in their pregnancies. So let me say again, RFRA, Religious Freedom Restoration Act, remains unaffected by the bill. In addition, the legislation does not amend Title VII of the Civil Rights Act of 1964 or otherwise limit religious exemptions for religious employers that exist under Title VII, nor does it amend the Americans with Disabilities Act of 1990 or otherwise limit the existing religious exemption that exists under that statute. Those exemptions still apply. So if employers are entitled to those exemptions, they still have them under this bill. Despite those existing religious exemptions, we find ourselves debating this unnecessary amendment that would further permit employers to deny accommodations for pregnancy-related conditions if that employer is religious. Now, the repercussions could be sweeping. Religious employers who do not believe in the use of assisted reproductive technology, such as in vitro fertilization, could deny accommodations to women who need medical assistance to successfully build a family. In addition, this administration has made it clear that its view of the Title VII religious exemption is broad enough to allow a religious institution to, quote, condition employment on acceptance of or adherence to religious tenets as understood by the employing contractor, thus enabling employers to deny jobs and accommodations or even fire women who are pregnant and divorced, who are pregnant out of wedlock, or are pregnant with a same-sex partner. Moreover, the current administration takes the position that for-profit companies, such as Hobby Lobby, may qualify for the religious exemption, thus broadening the entities entitled to seek the exemption and who may discriminate against pregnant working women based on the employer's own religious beliefs. So let me just say again, RFRA and other religious exemptions already exist to protect religious employers, and this bill does nothing to change that. The ranking member has indicated that she's offering the amendment to make it consistent with the Pregnancy Discrimination Act, an amendment to Title VII of the Civil Rights Act that makes it, an amendment to the Title VII of the Civil Rights Act that makes it unlawful to discriminate on the basis of pregnancy, childbirth, or related medical conditions. However, as I already stated, the amendment is not necessary. This legislation simply requires reasonable accommodations be made for pregnancy, childbirth, or related conditions. Existing religious exemptions already apply. The bill reflects a carefully crafted agreement by a broad coalition of organizations, some of whom have indicated in no uncertain terms that this amendment is a poison pill and that if adopted, it would no longer support the legislation. If adopted, this amendment will harm women's health and will harm their pregnancies by denying them the most basic of accommodations at work. This will force women to choose between their health and the health of their pregnancy and paying their bills, keeping a roof over their head, putting food on the table, and affording their prenatal care. This legislation was carefully and narrowly drafted to provide protections for pregnant women in every congressional district of America. And I reiterate the fact that it is supported by organizations, including the Chamber of Commerce, who support my amendment in the nature of a substitute without any amendments. I strongly urge a no vote on the gentlelady's amendment in the nature of a substitute and yield back the balance of my time. Others wish to speak to the amendment? Gentlelady from Oregon.
Thank you very much, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. I'm speaking strongly against this amendment. As the chairman explained, this is a carefully negotiated bipartisan bill. And the staff and the chairman especially has spent a lot of time getting this bill to here today. And I want to emphasize that pregnancy discrimination is not and should not be a partisan issue. Pregnant workers across the country are facing discrimination on the job, and we have the opportunity to protect the health and well-being and economic security of all pregnant and parenting workers and their families by passing this bipartisan Pregnant Workers Fairness Act. Also, several state legislatures across the country have already passed bipartisan legislation combating discrimination against pregnant workers. They've found that the certainty is good not just for pregnant workers, but also for businesses. And that's why Chairman Scott's amendment in the nature of a substitute has the support of a broad coalition of stakeholders, including groups representing pregnant workers, civil rights organizations, and the U.S. Chamber of Commerce. And it's truly unfortunate that after months of good faith negotiations, we could not reach a compromise on this bipartisan bill with our colleagues on the other side of the aisle on this committee. The ranking member's amendment would allow certain employers to deny pregnant workers reasonable accommodations. It provides a loophole for religiously motivated discrimination in the workplace. Quite frankly, it is a solution in search of a problem. And as the chairman mentioned, the Religious Freedom Restoration Act still applies in the situation. Now, I have in the past expressed concerns about abuse of RFRA. However, in the spirit of compromise, we did not exempt this legislation from RFRA. We know that the Pregnant Workers Fairness Act will make sure that all pregnant workers can stay safe on the job, period. I urge my colleagues to oppose this amendment and support Chairman Scott's bipartisan amendment in the nature of a substitute, which would take away needed protection. This amendment would take away needed protections for pregnant workers. I yield back the balance of my time and again encourage all members to oppose this amendment.
Does anyone else wish to speak to the amendment? Gentlelady from Pennsylvania first.
Thank you, Mr. Chairman. The proposed amendment, I think, adds controversy and confusion in a situation where it is not needed. The Pregnant Workers Fairness Act is not and should not be a partisan bill. It is about ensuring that pregnant workers can stay healthy and on the job regardless of the decisions they may make with regard to their pregnancy. According to the March of Dimes, when pregnant women are denied medically necessary accommodations, they face health risks, including miscarriage and premature births. Everyone should be able to agree that if this can be avoided by providing a reasonable accommodation, it should be. And this act has been supported by a very broad coalition. It reflects carefully balanced agreements. This amendment would be a poison pill that would undermine support for the bill from key constituencies, including groups representing pregnant workers and civil rights organizations. Let me just first say, a religious exemption is not necessary in this act. Religious employers are afforded significant protection under the current legal framework, including the ministerial exception and the defense provided in the Religious Freedom Restoration Act. The ministerial exception to Title VII of the Civil Rights Act is a constitutionally recognized exemption from civil rights law and not tied to any specific statutory language. Religious entities also have access to a defense under the Religious Freedom Restoration Act, RFRA. RFRA applies in situations where it can be shown that the federal government, including federal law, substantially burdens someone's religious exercise in a manner that is not narrowly tailored to further a compelling state interest. New laws must explicitly include language to exempt RFRA if there is an intent to do so. Because the Pregnant Women Workers Fairness Act does not include such exclusionary language, there is nothing in this act that changes an eligible employer's ability to argue that their religious beliefs are being substantially burdened without adequate justification. And most importantly, a religious exemption hurts vulnerable workers. Section 702 of Title VII, which is added to the Minorities Amendment, was supposed to only permit religious institutions to have a preference for hiring people of the same religion without violating Title VII's prohibitions on religious discrimination. With the current administration's interpretation of Section 702, an exemption for religious employers creates a loophole in this bill meant to provide pregnant workers with accommodations and emboldening religiously motivated discrimination. Given these broad interpretations of Section 702, we have to consider some of the consequences of the proposed Republican amendment. Should a pregnant woman married to a person of a different faith be forced out of her job as a cashier, losing her income and her ability to provide for her growing family, just because she requires a stool to sit on during her shift if her employer happens to object to interreligious marriage? If an employer imposes IVF on religious grounds, should a pregnant firefighter who conceived through IVF be forced to do something that would undermine her pregnancy or cause harm to her pregnancy and risk her health on the job? Should an employer's religious belief that a mother should not work outside the home result in a woman being discriminated against because of that pregnancy, and because of some accommodation that she needs. And finally, should an employer who opposes abortion on religious grounds be able to deny accommodations to a worker who suffers from complications after a therapeutic abortion, to sit for her job duties, risking her health and recovery? Finally, I submit to you that the Republicans' interest in consistency is a red herring. Unlike the Pregnancy Discrimination Act, the Pregnant Workers Fairness Act is standalone legislation. The Pregnancy Discrimination Act amended Title VII of the Civil Rights Act of 1964. Title VII allows religious employers to select employees on a religious basis. Similarly, the Americans with Disabilities Act also has religious exemption for employers that is not affected by this proposed act. And the Pregnant Workers Fairness Act does not amend either Title VII or the ADA, and thus those exemptions are unaffected by this legislation. Fundamentally, the amendment undermines the carefully balanced agreements that have been reflected in this legislation and jeopardizes the broad coalition of support for this bill. I yield back.
Thank you. The others wish to speak to the amendment. Gentlelady from Washington, Dr. Schreier.
Thank you, Mr. Chairman. I move to strike the last word.
Ladies recognized.
So first, I am thrilled to support the underlying legislation here. And let's be clear that the goal of the Pregnant Workers Fairness Act is to accommodate the temporary needs of pregnant women related to their pregnancy to result in a healthy and economically secure woman, a healthy pregnancy, and a healthy term baby. My colleagues seek to exempt religious organizations from protecting pregnant women. And with these common fundamental goals, it makes absolutely no sense that a pregnant woman who works for a religious organization should face a riskier pregnancy with risks to her health and risks to her child's health. And so I urge my colleagues to reject this amendment that puts pregnant women at risk and to vote for the underlying bipartisan bill, the Pregnant Workers Fairness Act. Thank you, and I yield back.
Thank you. Does others wish to speak to the amendment? Gentlelady from Massachusetts.
Thank you, Mr. Chairman. I'd like to strike the last word.
Ladies recognized.
I regret that this bipartisan bill, a bill that has the support of the AFL-CIO and the U.S. Chamber of Commerce, might be used to advance a narrow ideological agenda. The Religious Freedom Restoration Act was originally intended as a shield to defend the rights of believers. However, this ANS would allow RFRA to be used as a sword against those who assert their right to a reasonable accommodation due to a pregnancy. You know, at a time when fertility rates are declining despite the desire for many parents to have children, shouldn't we make it easier for women to remain in the workplace and not more difficult? Even the National Review, not exactly a left-wing magazine, reports in its latest edition that, quote, personal experience of economic volatility reduces birth rates by reducing the optimism that people feel about their economic futures, end quote. This ANS would add to that volatility. It will inspire fear of losing one's job because your employer holds different views about IVF or even unmarried couples having children. What good reason would be served by allowing an employer to deny reasonable accommodations to a pregnant worker? None. I urge my colleagues to oppose the ranking member's amendment and support the chairman's ANS. Thank you. I yield back.
Others wish to speak to the amendment. Gentlelady from Connecticut.
Mr. Chair, I move to strike the last word. I remind my colleagues that this bill is the result of months of good faith bipartisan negotiations, and this amendment strips away the spirit of that work. Putting additional barriers to life-saving reproductive care endangers women's lives. This amendment jeopardizes the health and well-being of workers across the nation and compounds a series of penalties that would stand in the way of patients accessing essential health care. This amendment would give an employer the ability to discriminate against a woman because of a personal health decision, a decision protected by the United States Constitution. Women have abortions for a number of complex and personal reasons, including rape and medical complications. According to the Guttmacher Institute, women who have an abortion often feel they have no other choice given their limited resources and existing responsibilities. This amendment only adds to the toxic stigma that women, when making reproductive decisions about their bodies, are doing something wrong, that they are not worthy of care or accommodations for a health procedure they have undergone, that if they decide to have an abortion, they will be punished at all levels of society, including by their employers. This amendment has incredibly dangerous and broad implications, opening the door for devastating discrimination. It could allow for an employer to discriminate against same-sex couples, workers that are pregnant and unmarried, or partners in an interracial or interreligious marriage. It would be so much more productive to continue the bipartisanship and collaboration to address loopholes in current law and make the workplace safer for everyone. If we are here to protect children, we must also protect mothers. This amendment is an affront to long-established law and medical reality. I urge my colleagues to oppose this amendment. I yield back.
Thank you. The others wish to speak to the amendment? If not, the question is on the amendment offered by the gentlelady from North Carolina. All in favor will say aye.
Aye.
All opposed, no. No. Noes appear to have it.
Mr. Chairman, could we have a recorded vote,
A
please?
recorded vote is requested, and pursuant to the chair's previous announcement, that vote will be postponed. Are there other amendments to the does the gentlelady from Connecticut withdraw a point of order?
I withdraw my point of order.
The vote on this amendment will be postponed. Are there other amendments? If not, consideration of the bill will be postponed until, and votes rolled until after consideration of H.R. 5191. Seeing that all amendments of 2694 have been dispensed with and all votes postponed, the committee will now begin consideration with H.R. 5191. The bill will circulate in advance. Printed copies are available, and the clerk will designate the bill.
H.R. 5191 to reauthorize the Runaway and Homeless Youth Act and for other purposes.
Without objection, the first reading of the bill is dispensed with. The second reading of the bill, without objection, the bill will be considered as read and open for amendment at any point. Any amendment offered shall be considered as read. Are there amendments to the legislation? I recognize the gentlelady from Washington, Ms. Jayapal, for the purpose of offering an amendment in nature of a substitute. Clerk will designate the amendment in nature of a substitute.
Amendment in the nature of a substitute to H.R. 5191 offered by Ms. Jayapal of Washington.
Without objection, the amendment will be considered as original text and open to amendment at any point. The amendment in the nature of a substitute has already been distributed and is in each of your folders. I recognize the gentlelady from Washington for 5 minutes to explain the amendment in the nature of a substitute.
Thank you, Mr. Chairman. The amendment in the nature of a substitute makes minor changes to the bill. It clarifies the difference between federal facilities and transitional living youth shelter projects, and it replaces references to the prior Reauthorization Act with the title of the bill that we are considering today. Mr. Chairman, no one grows up wanting to be homeless. The ANS and the underlying bill represent a bipartisan agreement to update the Runaway and Homeless Youth Program, which serves youth facing circumstances beyond their control: poverty and stagnant wages, institutionalized racism, homophobia, and underfunded systems of foster care, affordable housing, mental health care, and education. This is a crisis across our country for so many young people. According to the Voices of Youth Count report produced by Chapin Hall at the University of Chicago, 1 in 10 young adults ages 18 to 25 and 1 in 30 adolescents ages 13 to 17 experiences homelessness in 1 year. Black youth face an 83% higher risk of experiencing homelessness, and LGBTQ plus youth are at a 120% higher risk. Native American youth are also more likely to become homeless, especially in rural areas. Many of us on this committee are parents or have young people in our families that we're close to. Many of us hear about the heartbreaking circumstances of how and why young people become homeless. All of us understand that protecting our young people, giving them the resources to succeed early in life, and keeping them safe and secure must be at the top of our list as Republicans and Democrats. Like many of you, I've been deeply moved by the stories and advocacy of directly impacted young people, like those in my own district who have been working through our annual Washington State Youth Leadership Summits. Our young people across the country have raised the alarm and called on Congress to step up our game. We know that runaway and homeless youth are in desperate need of trauma-informed services, especially for youth of color, LGBTQ plus young people, and youth with disabilities. That's exactly what this bill does. It ensures that grantees provide culturally, linguistically, developmentally, and gender-appropriate services. It expands the length of time that youth can spend in emergency shelters from 21 to 30 days. Some states, including mine, have gone further, allowing youth to spend up to 60 days in a shelter, which helps us get closer. This bill helps us get closer to a humane length of time for all states. And it helps prevent putting youth in the untenable position of shelter hopping, which disrupts and destabilizes their lives with changes in case managers, mental health counselors, and schools. While 30 days is still not enough in many cases, it does provide some increased measure of stability for homeless and runaway youth. The bill also increases the eligible age for services to 25 at the option of providers, recognizing the extensive research indicating that our brains are not fully developed until age 25. During development, our brains are more vulnerable to damage from drugs, environmental toxins, trauma, and stress, but also more responsive to positive influences, making interventions like those funded through this bill especially significant. The bill also requires that homeless youth receive suicide prevention services. One Northwestern University study shows that a stunning 53% of homeless LGBTQ+ youth have attempted suicide. We have to do everything we can to reverse this horrifying trend. Finally, the bill adds non-discrimination language that codifies existing regulation to ensure all homeless youth have access to federally funded programs. This change recognizes that between 20 and 40% of homeless youth population nationally identify as LGBTQ+. Unfortunately, the administration has begun a process to remove anti-discrimination regulations across all HHS programs, putting homeless youth across the country at risk of discrimination on the basis of sexual orientation and gender identity. This is unacceptable. The non-discrimination language in this bill is the exact same language that received bipartisan support in both chambers in 2013 when it was codified into the Violence Against Women Act. Mr. Chairman, I know there are many things that divide us here in Congress, but this bill should not be one of those. This is a bipartisan, bicameral bill to help vulnerable youth. It is also an opportunity to address the broader crisis of homelessness and housing instability facing our country, where many, many districts experience homelessness of almost 50% of homeless adults first experiencing homelessness before the age of 25. For all these reasons, I urge my colleagues to support the ANS and the underlying bill, and I yield back the balance of my time.
Thank you. Are there others who wish to speak to the amendment? Gentleman from Pennsylvania.
Thank you, Mr. Chairman. I have concerns with the amendment in nature of substitute. This is emblematic of the House majority this session, once again considering a partisan messaging bill. As it's been said earlier, Republicans were never afforded an opportunity to work in a bipartisan manner on this bill. And that's unfortunate for two reasons. First, there are many problems with the underlying text of the bill that could have and should have been addressed. Second, and this is why it is particularly frustrating that we are not allowed an opportunity to work on this bill in a bipartisan manner. We actually agree with our colleagues on the other side of the aisle that we should help protect American youth from the dangers of homelessness and what it presents. Sadly, we know that in the United States, around 700,000 youth are homeless. These children face devastating dangers and risks that can compromise their safety and health. Unfortunately, but not surprisingly, it appears the majority's amendment in the nature of substitute does not improve their partisan legislation. First, the spending levels in the amendment are beyond unreasonable. We owe it to the runaway and homeless youth seeking help the grantees providing these critical services and the taxpayers to be more honest about the funding that will be made available. Yet the Democrats make promises on funding they know will not be met. Current appropriations have not yet hit even the authorized levels in current law, let alone the unrealistic levels included in this proposed legislation. By increasing the authorizations in the current law, the Democrats are promising money that grantees will never see and breaking the #1 rule of success by not aligning expectations with reality. Second, in the lack of accountability in this amendment in the nature of the substitute, we also owe it to these individuals to ensure we have accountability measures in place. Unfortunately, the underlying bill does not include simple, bipartisan language that would help protect both participants in the programs and the taxpayers. In contrast, the Republican amendment implements key accountability measures, making the bill a more reasonable approach. For example, the Republican amendment ensures that grantees who are not meeting their purpose will not continue to receive grants. As responsible stewards of taxpayer dollars and ensuring that the help gets where it needs to get, we need to make sure the federal government isn't in the business of funding grantees who fail to do what they said they would do and fail to appropriately serve the youth that need help. By only funding programs that work and provide needed services, we serve the American taxpayer better and those who need the services so that they can have the assurance that the taxpayers, that their hard-earned dollars will be spent effectively and that the people that need the help will actually get the help. I look forward to hearing from my colleagues speak further about the Republican substitute as it puts forward productive and common sense policy that includes accountability measures Democrats failed to address. I strongly urge my colleagues to vote no on the Democrats' amendment in the nature of the substitute. Thank you, and I yield back.
Your gentleman yields back. Does anyone else wish to speak to the amendment? Gentlelady from California, Ms. Davis.
Thank you, Mr. Chairman. Mr. Chairman, I commend what this bill does for the LGBTQ runaway and homeless youth. The sad truth remains that LGBTQ youth and young adults experience homelessness at significantly higher rates than their straight and non-transgender peers. And in fact, about 40% of youth experiencing homelessness self-identify as LGBTQ. And unfortunately, as many of us know, these young people continue to face discrimination in accessing services. Transgender Americans report distressing levels of discrimination. In the 2015 U.S. Trans Survey, the largest survey of transgender Americans ever conducted, 7 out of 10 respondents who stayed in a shelter reported some form of mistreatment, including being harassed, assaulted, or kicked out for being transgender. I have a story of one particular young person who shared their concerns with us. This trans youth tried to access services at a local shelter and shared that she did not have the best of experience with staff during intake, but she felt that she could move on, that she was somewhat accepted there. But her experience with other women there was not so positive, and some women complained that they did not feel safe with her in the shelter. She shared that the staff did not support her through this, and so she decided to leave the shelter, to sleep on the street, that was better for her than being under this situation. And she went out to find better services for herself. There are many other issues that have come to our attention. Some of the issues have been raised by our local LGBTQ homeless youth, and they talk about the fact that they do not have safe access to restrooms. That continues to be a concern. Folks are sometimes still told that they have to use restrooms based on the sex they were assigned at birth, or use that restroom based on what is on their identification card. Folks being intentionally misgendered is still all too common. Homeless youth report that some folks still do not respect their pronouns, even after correcting others. Discrimination perpetuated by peer groups or other non-staff folks at shelter programs persist. This is very, very real to those young people who experience this, and as one can imagine, it's very hard to move on with one's life under those circumstances. So I just wanted to really highlight for all of us that there is a critical need for explicit protections in statute to ensure that all runaway and homeless youth are treated fairly, they're treated with dignity, and they're treated with respect. Thank you, and I yield back.
Speak to the amendment nature substitute. Gentlelady from North Carolina.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I want to voice my support for the ANS to H.R. 5191. One of the most troubling statistics that I see annually in my state of North Carolina is the occurrence of human trafficking. Every year, North Carolina ranks in the top 10 of reported human trafficking cases. And in the city of Charlotte, my home district typically leads the state in trafficking cases. I've heard countless tragic stories from many of our local stakeholders who dedicate their lives to providing services to homeless youth, of the many that still have trauma because of their experiences being trafficked. About a fifth of all homeless youth suffer from this reality, and our LGBTQ youth are twice as likely to be taken victim. By passing H.R. 5191 today, we stand up for the most vulnerable among us. And we do so in a way that states plainly that discrimination is never acceptable, that the lives of our Black, brown, Muslim, disabled, and LGBTQ homeless youth are just as entitled to help as anyone else. I strongly urge support for this legislation, and Mr. Chair, I yield back the balance of my time.
Thank you. Does others wish to speak to the amendment nature for substitute? Gentlelady from Oregon.
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. As Chair of the Civil Rights and Human Services Subcommittee, I am so pleased to co-sponsor and support the bipartisan Runaway and Homeless Youth and Trafficking Prevention Act of 2019 and the amendment in the nature of the substitute. Today, millions of youth across the country, including in my home state of Oregon, do not have access to a stable home. And for many of them, the effects of homelessness are not isolated to days or weeks or months. Without access to the support and resources that come with stable housing, youth are far more likely to drop out of school, fall prey to exploitation and human trafficking, and remain homeless as adults. If these young people receive the services they need to transition out of homelessness, they can thrive as self-sufficient individuals. That is a good investment, and it's one that Congress can and should make by updating and funding the Runaway and Homeless Youth Act. The bill before us today, the amendment in the nature of the substitute, would expand and improve services for homeless youth. The provisions will help strengthen relationships with family members or important adults in the lives of homeless youth when it is in the best interest of the child. It importantly adopts trauma-informed practices that support youth whose experiences have had long-lasting effects on their mental health and well-being. Notably, this bill will also strengthen federal investments in three main programs under this law: the Basic Center Program, the Transitional Living Program, and the Street Outreach Program, all of which provide critical services to homeless youth and support their transition into safe and stable homes. And critically, this bill will make sure that programs do not discriminate against youth based on race, color, religion, national origin, sex, gender identity, sexual orientation, or disability. This is critical. We know that LGBTQ youth, including many in the metropolitan Portland and Northwest Oregon areas, have a disproportionately high risk of homelessness. Collectively, these updates will help providers better support homeless youth. One of the providers in the district I represent, Yamhill Community Action Partnership, relies on these programs to provide resources and services to rural homeless youth who are too often underserved. This is not just an urban issue. It is happening everywhere. In addition to providing critical services such as a drop-in center, a shelter, peer support, and mental health counseling, this organization recently launched the You Matter initiative. They recognize that homeless youth are at greater risk of suicide, severe anxiety, depression, and low self-esteem. And the You Matter initiative is a weekly rally where staff members and some of the young people they serve meet at the flagpole on the highway in Newburgh, Oregon, and hold up messages of love and support to combat youth suicide. They're reaching out, they're doing that outreach so that members of the community who are struggling know that the services are available. The updated Runaway and Homeless Youth Act will support initiatives like this by providing counseling and suicide prevention services to homeless youth. Passing this bill is an important step toward making sure that all young people have access to safe and stable housing that empowers them to reach their full potential. I am grateful to my bipartisan colleagues, Representatives Yarmouth, Bacon, Hayes, and Jayapal, for their leadership in moving this bill forward, and I urge my colleagues to support the amendment in the nature of a substitute, and I yield back the balance of my time.
Thank you. Others wish to speak to the amendment? Gentlelady from Florida, Ms. Wilson.
Mr. Chairman, I'm pleased that we're taking up this critical bill in our committee today. The Runaway and Homeless Youth and Trafficking Prevention Act of 2019 provides much-needed resources and protections for our vulnerable youth. I'm especially pleased that $75 million will be authorized to identify and support young people who are the victims of human and sexual trafficking. 57% of all juvenile prostitution arrests are of Black children. It boggles my mind that these children are arrested. Hopefully, this bill will help to educate everyone to the fact that there is no such thing as a child prostitute. These children are victims of child sex trafficking and should be protected, not prosecuted. Furthermore, it is especially important for members of the LGBTQIA+ community to know that the language in this legislation will affirm their full humanity by protecting them from discrimination when accessing the vital resources of this bill. I also want to point out that in my district, I visit with school children to discuss sex trafficking and ways that students can identify and avoid sex traffickers. It's important to provide safe places for those who are being victimized and education for those who can avoid the clutches of these abusers. For these reasons, I fully support this bill and urge my colleagues to do the same, and I yield back.
Thank you. Do others wish to speak to the amendment? Gentleman from New York.
Mr. Chairman, I move to strike the last word on the amendment in the nature of a substitute.
Gentleman's recognized.
Thank you, Mr. Chairman. As policymakers, it's our responsibility to ensure that every child has access to the tools they need to succeed. Unfortunately, a growing number of our nation's children face difficulties finding resources to simply survive, let alone thrive. I'm proud that our committee is taking steps here to address the youth homelessness crisis in our nation and strengthen protections that prioritize the well-being of our children. As others have talked about their district, in my home community of Rochester, New York, we are fortunate to be home to the Center for Youth, an organization providing critical resources to youth in the community, including emergency shelter, supportive services, and youth development opportunities. Centers like this one in my district, and others that my colleagues have talked about throughout the country will benefit greatly from this legislation we are considering here today, helping to extend their reach and impact on our nation's most vulnerable children. I'd particularly like to spotlight the non-discrimination clause included in the legislation. We know that a significant percentage of youth benefiting from services funded through the Runaway and Homeless Youth and Trafficking Prevention Act are LGBTQ, and I am proud that the Center for Youth in my district has established itself as an LGBTQ safe zone, and I hope that the non-discrimination clause in the legislation will help foster similar safe environments and organizations that protect an already vulnerable community. No child should have to face the trauma of being forced to leave their home only to find that they are refused services due to their sexual orientation. I applaud this committee for its work. I applaud you, Mr. Chair, and the sponsors of the bills, and urge all of my colleagues to join me in supporting this legislation.
Thank you.
And I yield back.
Others wish to speak to the amendment? Gentlelady from Pennsylvania.
Thank you, Chairman Scott. I move to strike the last word. According to Valley Youth House, there were 700 identified children experiencing homelessness in the Allentown School District in Pennsylvania 7. 700 in just one of the many school districts in my congressional district. That is just the number that have been identified. Every year, outside of the PPL Center in downtown Allentown, Lehigh Valley Health Network holds a ceremony for people who faced homelessness and have died. A wall in remembrance of those losses has been erected in one city center in Allentown. Included in the remarks on the day of the wall's dedication in 2016 were the words, "No one dies alone." There are far too many names on the wall already. My hope is that one day a wall will not be necessary, that there will be a day where we reach people going through homelessness before it is too late. I can think of no better way to remember those losses than passing this bill out of committee. It reauthorizes and makes improvements to federal programs that combat youth homelessness and strengthens the focus on trauma-informed services. For kids who can safely return home, the bill will provide short-term housing and counseling services that aim to strengthen their connections to their family and the caring adults in their lives so that they are able to return to their homes. For kids who cannot safely return home or who are ready to become self-sufficient, the bill will provide longer-term housing, counseling, and education services to help them transition into independent, self-sustaining adults. And critically, the bill provides funding for suicide prevention among youth experiencing homelessness. Homelessness is not just a standalone concern. It is one that dovetails into other crises like the drug and suicide epidemics. The return on investing in our youth should never be underappreciated. Let's make that investment today. Let's give the 700 children in Allentown, the homeless children in the Allentown School District, as well as throughout this country, a better shot at healthy and productive lives. Let's get this bill out of committee and onto the House floor without delay. And with that, I yield back.
Gentlelady yields back. Gentlelady from Georgia.
Thank you, Mr. Chairman. I move to strike the last word. According to the 2018 Atlanta Youth Count Study, over 3,000 youth are currently experiencing homeless in the Atlanta metropolitan area. This number has remained virtually unchanged since the last study was conducted in 2015. Across the state of Georgia, this number is even higher. At the total, at this moment, there are nearly about 40,000 homeless youth in the Atlanta metropolitan area. And these numbers are truly heartbreaking, especially when coupled with the fact that homeless youth are more likely to have been exposed to some form of human trafficking in their lifetimes. Because Georgia is the home to the nation's busiest airport and is a gateway to the rest of the country, young people in the state are even more at risk of becoming victims of human trafficking. This is recognized by the fact that Georgia has been listed as one of the 14 cities across the country that are hubs for human trafficking since 2005. In fact, the same 2018 Atlanta Youth Count Study found that over half of the youth that were surveyed in Atlanta had experienced one or more forms of human trafficking. The Runaway and Homeless Youth Trafficking and Prevention Act is a vital piece of legislation for those who call Georgia home because of the high rates of homelessness and human trafficking that's experienced across the state. H.R. 5191 gets us closer to solving the issues of human trafficking that is an all too familiar nightmare for many living in the Atlanta metropolitan area. With the additional $75 million that would be authorized funding outlined in this bill, we will be able to help identify homeless youth who have experienced human trafficking and provide the services and trauma based upon the care that they need. I'm very happy to support the amendment in the nature of a substitute as well as the underlying bill, and I encourage all of my colleagues to do the same and vote yes. Thank you, and I yield back the balance of my time.
Thank you. Gentleman from California, Mr. Takano.
Mr. Chairman, I move to strike the last word.
Gentleman's recognized.
Mr. Chairman, I strongly support the Runaway and Homeless Youth and Trafficking Prevention Act, a bill that will help states and localities tackle youth homelessness by expanding services for street outreach, transitional living, and basic centers. Since 1974, these critical programs have supported organizations like Operation Safe House, a local organization in my district in Riverside, California. This organization provides emergency shelters, community support, as well as intervention and outreach services to youth. Youth homelessness is on the rise, and California has some of the highest numbers of homelessness in the country. Reports show that there are nearly 4 million youth experiencing homelessness every year in the United States. However, we know that these numbers are largely underreported, as it is really hard to capture the full scope of homelessness among our youth. Runaway and homeless youth programs are critical at protecting our youth from violence, exploitation, and human trafficking. The funding in this bill allows organizations like Operation Safe House to address the root cause of the homelessness and work towards prevention with a focus on trauma-informed services. This bill builds upon the last reauthorization and ensures that we take into consideration the increasing obstacles that many young people of different demographics experience, including the over 40% of homeless youth that identify as LGBTQ. It is time for Congress to reauthorize the Runaway and Homeless Youth Act. I urge my colleagues to vote yes on the ANS and oppose any harmful amendments that would strip critical protections from the legislation. Mr. Chairman, I yield back.
Thank you. The others, gentlelady from Connecticut.
Mr. Chair, I move to strike the last word.
Gentlelady is recognized.
I'm so proud to be a part of this committee as we mark up a critical piece of legislation that I helped to introduce several months ago, a bill that offers real solutions and help for the over 4 million teens and young adults experiencing homelessness in our country every year. In 2019, homelessness in the United States rose nearly 3%. As this national crisis grows, it is vital that we prevent ourselves from becoming desensitized and to the suffering of our neighbors or complacent in the search for solutions. We must become acquainted with the faces of Americans that sleep on our streets, in their cars, or on the floors and couches of family and friends. Over 1.4 million school-aged children are homeless. Families with children make up 1/3 of the total homeless population. Young parents are also more likely to experience homelessness. While homelessness is a public health issue, it is also a civil rights issue. LGBTQ youth and Black and Latinx youth are pushed into homelessness at rates that are disproportionately higher than their peers. The changes that are proposed would remove the requirement that LGBTQ youth even be served. In Connecticut, almost 4,400 people under the age of 25 are either homeless or face the trauma and uncertainty of housing insecurity. 23% of Connecticut's homeless youth are LGBTQ. It is a pervasive issue and deserves our immediate attention. But it goes beyond having a roof over your head or not having a permanent place to stay. Homelessness, access to higher education, and poverty are inextricably linked. Not having a permanent address makes it more difficult for a person to apply for a job, to register for school, or to register to vote. The Runaway and Homeless Youth and Trafficking Prevention Act would dedicate significant funds towards getting homeless youth on the path towards a permanent home. It would ensure that every young person would be protected by law and by providers. It would require local partners and programs to provide the documentation homeless youth need to fill out a FAFSA or apply for financial aid. I urge my colleagues to come together to protect young people facing crisis. We are all measured by what we do for the most vulnerable among us. I urge my colleagues to support this bill. I yield back.
Thank you. Others wish to speak to the bill? Gentleman from Michigan.
Mr. Chairman, I move to strike the last word.
Let's recognize for 5 minutes.
Thank you, Mr. Chairman. I want to express my support for the amendment in the nature of a substitute, and I thank Representatives Yarmouth, Bacon, Jayapal, and Hayes for their leadership on this bill. In Michigan, more than 34,000 children enrolled in public K-12 schools are experiencing homelessness, And of those kids, more than 14%, or 4,800 of them, are unaccompanied, facing this crisis without a parent or a guardian. These staggering numbers are heartbreaking enough, and yet they represent Michigan alone. We all know that childhood and adolescence are full of challenging transitions under the best of circumstances. No child should have to grapple with the added uncertainty and lack of support that comes with homelessness. The legislation we are considering today will make significant improvements to federal services for all homeless youth. The increased federal support, greater focus on trauma-informed services for diverse communities, and non-discrimination protections put forward in this bill will ensure we reach all youth in need of these critical services. I urge my colleagues to vote yes on the ANS and the underlying bill, and I yield back the balance of my time.
Thank you. Does others wish to speak to the amendment? Gentlelady from Florida.
Thank you, Mr. Chairman. I move to strike the last word. Oops. LGBTQ youth homelessness in South Florida, like in many parts of the nation, is an invisible crisis that experts and groups find increasingly difficult to eradicate. This vulnerable segment of our population isn't standing on the side of a road with handwritten signs asking for help, or near larger groups of homeless adults in densely populated urban communities. Many simply spend most of their days securing a place to sleep in the evenings and staying off the streets to avoid authorities. According to a 2015 study by the Williams Institute, rejection by family members is the most common reason cited for homelessness among queer youth. Some are forced out of their homes, while others run away from the emotional or physical abuse. Substance abuse and domestic violence are the second most frequently cited causes, followed by aging out of foster care with no proper support network. Furthermore, 30% of the LGBTQ youth experiencing homelessness are also reported to have had contact with the juvenile justice system. One experience that directly connects LGBTQ youth homelessness with increased involvement in the juvenile justice system is mistreatment in schools. Research shows that more than half of the LGBTQ students hear homophobic remarks in their schools, that 6 in 10 students report feeling unsafe at school because of their sexual orientation, and 4 in 10 reported feeling unsafe at school because of how they express their gender. Experiences with bullying in schools coupled with family rejection in the home results in some youth skipping school or running away from home. In my South Florida community, the high cost of living is another significant factor. For an 18-year-old with a minimum wage job, it's practically impossible to afford to live in even a studio apartment without any type of assistance. Those struggles become even more significant when considering the challenges that trans and gender non-binary youth experience in finding employment, shelter, and social acceptance. It's important to note that once on the streets, or when housed in emergency shelters, runaway and homeless LGBT youth are disproportionately affected by HIV, sexual assault, violence, and inadequate access to behavioral or mental health resources, especially if they're people of color or come from low-income backgrounds. Mr. Chairman, young LGBTQ people cannot overcome the barriers of homelessness on their own. They need a support system to provide adequate resources and services in order to avoid further chronic homelessness. H.R. 5191 isn't perfect, but there's no denying that it should be funded more robustly. But this bipartisan legislation makes significant changes to the non-discriminatory language in support of homeless and runaway LGBTQ youth and will provide the necessary tools to protect the most vulnerable among us. I urge all my colleagues to vote in favor of the ANS and the underlying bill. Thank you, Mr. Chairman. I yield back.
Thank you. The others wish to speak on the amendment. Gentlelady from Washington.
Thank you, Mr. Chairman. I would like to yield my time to my colleague, Mrs. McBath from Georgia.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you for my colleague for yielding. Given the high risk of homelessness in the LGBTQ population, it's important to protect these youth from discrimination and ensure that all youth have access to federally funded services to help them find stability and support during the moments of hardship and vulnerability. The bill that we're marking up today includes strong non-discrimination language to ensure just that very thing. The bill includes non-discrimination language that is identical to a similarly situated provision added to the Violence Against Women Act that passed through Congress with strong bipartisan support more than 6 years ago. This language is also a codification of the current non-discrimination protections in the program's regulation. Our colleagues on the other side of the aisle claim that the non-discrimination provision included in the underlying bill is unnecessary. They've told us that we should wait for our colleagues in other committees to enact broad, sweeping legislation prohibiting discrimination on the basis of sexual orientation and gender identity across all federal programs. Moreover, recent actions by the Trump administration have made it clear that this committee needs to act quickly. The administration last month proposed to repeal the very agency-wide HHS non-discrimination provisions that protect our LGBTQ youth being served by the RHYA programs from discrimination. As such, it is incumbent on the members of this community to protect homeless children and youth by codifying the non-discrimination provisions included in the legislation that is before us today, as this committee has done time and time again in many other programs under our jurisdiction. I yield back.
The lady yields back. Are there others who wish to speak to the amendment? If not, being no further discussion on the amendment in nature of substitute, the committee will now move to consideration of amendments. Does any member wish to offer an amendment?
Mr. Chairman, I have an amendment at the desk.
Gentlelady's amendment. Clerk will report the amendment.
Substitute amendment to the amendment in the nature of a substitute to H.R. 5191, offered by Ms. Fox of North Carolina.
Mr. Chairman,
Gentlelady from Oregon.
I reserve a point of order on the amendment.
Gentlelady reserves a point of order, and the gentlelady from North Carolina is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. We have a duty to help protect American youth from the dangers homelessness presents. The legislation we're here to mark up today, the Runaway and Homeless Youth and Trafficking Prevention Act of 2019, should have strong bipartisan support. However, as I mentioned earlier, committee Republicans were denied an opportunity to engage in bipartisan talks to address the failings of this important legislation. That is why committee Republicans are offering alternative legislation. The Republican substitute is a strong proposal that will better help youth harmed by sexual exploitation and substance abuse disorder. The Republican amendment is clear. Individuals seeking help must be served, and grantees must provide or refer services to those seeking help. Additionally, grantees must follow non-discrimination laws. If a grantee doesn't provide the services required or give the help they are mandated to give, they cannot receive funding under this program. It's as simple as that. The amendment also includes responsible funding levels, which are consistent with recent funding trends. In contrast, the Democrats make promises on funding they know to be untrue. Current appropriations have not yet hit even the authorized levels in current law, let alone the unrealistic levels included in the Democrats' legislation. By increasing the authorizations in current law, the Democrats are promising money that grantees will never see. If we're going to be serious about putting forward good policy, it will require common sense funding authorizations. By doing so, we can also help grantees more accurately plan for available funding so they can better operate their programs. The Republican amendment does not cut funding for these important programs. Committee Republicans believe that Congress owes it to the runaway and homeless youth seeking help, the grantees, and the taxpayers to be more honest about the funding that will be made available, and the Republican amendment does that. Our amendment also implements key accountability measures. For example, grantees who are not meeting their purposes will not continue to receive grants. This language will help ensure taxpayers don't continue to fund poor-performing grantees that are not meeting the requirements of the program or project as they said they would. It also requires grantees to plan for alternative funding so youth receiving services will not be harmed if federal funding ends. The accountability measures included in this amendment will help better serve runaway and homeless youth and protect taxpayer dollars from waste, fraud, and abuse. All of us owe a duty to American taxpayers to ensure that their hard-earned dollars are spent properly. I wish our Democratic colleagues would have invited us to work in a bipartisan fashion on today's legislation. The Republican substitute is a reasoned and common sense approach that will serve youth, grantees, and American taxpayers. I urge my colleagues to vote yes on this amendment.
Gentlelady yields back. I recognize myself in opposition to the amendment. I'd like to first note, however, that the ranking member's amendment does make improvements to the underlying bill related to substance abuse disorder within this vulnerable population. It would have been nice if we could have worked together on a bipartisan amendment in nature of a substitute, but to better help homeless youth. But make no mistake, the underlying legislation without this amendment is bipartisan, enjoys the support of both Republicans and Democrats in the House and Senate, but unfortunately, the legislation involving LGBTQ youth served by the Runaway and Homeless Youth Act was a stickler that we couldn't get past. Thus, the committee minority was unwilling, and we can talk about who invited who and what, but the fact is that unfortunate impasse ended the negotiations. The amendments in the amendment nature of a substitute actually strips so many protections from this vulnerable population, which is overrepresented in the homeless and runaway youth population. And this is unacceptable. It is especially unacceptable because this program serves so many LGBTQ youth, and as such, I cannot support the gentlelady's amendment, but would want to look forward to incorporating some of the substance abuse disorder language into the bill before moving it to the floor. But I urge my colleagues, all of my colleagues, to reject this amendment and join bipartisan supporters supporting the underlying bill without this amendment in nature of a substitute. I yield back. Others wish to speak to the amendment? Gentlelady from Washington.
Thank you, Mr. Chairman. I rise in strong opposition to this amendment. First, let's just remember, as you just said, that this is a bipartisan, bicameral bill that is the product of months this time around and years and past years as we've passed this bill of careful negotiation between Republicans, Democrats, providers, and all the interested stakeholders. And I'm disappointed that this today has turned into a partisan exercise because it really should not be. Second, this Republican amendment reverts authorization levels to current levels. That's about $37 per youth per year. Our reauthorization, which again is a bipartisan compromise, increases it to about $73 per youth per year. Now, I think many of us on the Democratic side would like to see this number be even higher, but we are respecting the bipartisan nature of this compromise. We all hear from local providers in our district how underfunded these programs are, and this level that is in our bill recognizes that we need to do more. We need to listen to providers and directly impacted youth who feel the need every day. And we have to stick with this carefully crafted bipartisan negotiated funding level. In a national study of youth homelessness commissioned by the Department of Housing and Urban Development, Chapin Hall at the University of Chicago found that LGBTQ youth are 2.2 times more likely to experience homelessness than their non-LGBTQ peers. Around the country, 20% or 1/5 of all homeless youth are LGBTQ, with rates reaching as high as 40% in some counties like mine. Given the high risk of homelessness in the LGBTQ population, it is important to protect these young people from discrimination and ensure that all youth have access to federally funded services to help them find stability and support during these moments of hardship and vulnerability. The bill we're marking up today includes strong non-discrimination language to ensure just that. The bill includes non-discrimination language that, again, is identical to similarly situated provision that was added to the Violence Against Women Act that passed through Congress with strong bipartisan support. This language is also a codification of the current non-discrimination protections in the program's regulation. Our colleagues on the other side of the aisle claim that this non-discrimination provision included in the underlying bill is unnecessary. They've told us that we should wait for our colleagues in other committees to enact broad sweeping legislation prohibiting discrimination on the basis of sexual orientation and gender identity across all federal programs. But congressional Republicans have no plans to make such a legislation a reality, nor does that plan accord to precedent. This committee, as well as many others in this chamber, has enacted statutory non-discrimination in several statutes, including Head Start and the Higher Education Act. Moreover, recent actions by the Trump administration have made it clear that this committee needs to act quickly. The administration last month proposed to repeal agency-wide HHS non-discrimination provisions that protect LGBTQ individuals from discrimination in social service programs. As such, it is incumbent on the members of this committee to protect homeless children and youth by codifying the non-discrimination provisions included in the legislation before us today, as this committee has done time and time again in many of the programs under our jurisdiction. Mr. Chairman, this shouldn't be hard. The non-discrimination language in this bill is not new, and it has been supported by Republicans since 2013. We do not have the luxury of time. LGBTQ youth who are homeless today are at risk of being denied services thanks to the Trump administration's anti-LGBTQ actions. Mr. Chairman, I end with some numbers. What we're talking about is 700,000 youth between the ages of 13 and 17 experiencing homelessness. 3.5 million young adults ages 18 to 24 experiencing homelessness during a 12-month period. And on any given night, we are talking about 41,000 youth between 13 and 25 experiencing homelessness. None of us would want those children to be discriminated against, and we should put aside partisanship and pass this already bipartisan, bicameral, negotiated bill. I urge a no vote on this Republican ANS, and I yield back the balance of my time.
The lady's time has expired. Does
Chairman.
anyone else wish to speak to the amendment? Gentleman from Michigan.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman's recognized.
Some of my colleagues have noted, committee Republicans, and I emphasize the word committee Republicans, were denied an opportunity to engage realistically in bipartisan discussions to address the failings of the Democrat legislation to reauthorize the Runaway and Homeless Youth Act. Any bipartisanship came with members that weren't on this committee. However, I was recently looking back at enhancing services for runaway and homeless victims of Youth Human Trafficking Act of 2014, H.R. 5076, which truly was a bipartisan bill that passed on suspension, that dealt with these issues, seriously dealt with these issues. Republicans and Democrats came together to work on these important reforms and tackle these serious issues in a bipartisan manner. Human trafficking is an issue that impacts my district, and I've worked with members of this committee like Mr. Sablan to help enhance detection and end this evil practice. That's why the partisan process of the bill before us today is so disappointing, regardless of what some of my colleagues are saying on the other side of the aisle. These issues impact both urban areas and rural areas. We actually know homelessness impacts rural and urban areas' youth at the same rate. And the amendment offered by Dr. Fox ensures rural communities will have a better opportunity to receive funding. As a member representing many, many rural areas, it's incredibly important that these areas are not left behind or forgotten. Youth homelessness is not a partisan issue and is also not strictly urban issue. We cannot treat it as such. The amendment will ensure we do not leave our rural communities behind. Additionally, I'd like to highlight the amendment includes additional accountability measures to ensure taxpayer dollars are spent wisely. Specifically, it ensures grantees who do not meet their stated purpose will no longer receive funding. It also requires grantees to plan for alternative funding so youth receiving services will not be harmed if federal funding ends. This language will help ensure taxpayers don't continue to fund poor-performing grantees that are not meeting the requirements of the program and are not appropriately serving the youth that need help. Hardworking American taxpayers deserve to know where their tax dollars are going, and they deserve to know there are accountability measures so these dollars are not wasted. When it comes to protecting vulnerable children, we aren't Democrats or Republicans. We're moms and dads, aunts and uncles, siblings and grandparents, loving community members. Every second consumed by politics is time that could have been spent helping the victims who don't have political parties and could ultimately be signed into law. It's my hope we can put aside partisanship and return to the days of an enhancing services for runaway and homeless victims of Youth Human Trafficking Act of 2014 that was passed on suspension in a bipartisan way. Mr. Chairman, I yield back.
Gentleman yields back. Does the gentlelady from Oregon withdraw her, insist on her point of order? Does the gentlelady, point of order is withdrawn. Does anyone else seek recognition on the amendment? If not, the question is on the amendment offered by the gentlelady from North Carolina. All in favor will say aye.
Aye.
All opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chairman, can we have a recorded vote?
Recorded vote is requested. Pursuant to the chair's previous announcement, that vote will be postponed. Does anyone else seek to offer an amendment? If not, we will proceed to the postponed votes. We will first be voting on the amendment. The amendments to H.R. 2694 in the first with the amendment offered by the ranking member, which would be an amendment to the original amendment nature of a substitute. So the first question is on the amendment offered by the gentlelady from North Carolina to H.R. to the amendment nature of a substitute to H.R. 2694. Are there any questions of what we're voting on? If not, I'm sorry. The clerk on that amendment, the clerk will call the roll.
Chairman Scott?
No.
Chairman Scott votes no. Mrs. Davis? No. Mrs. Davis votes no. Mr. Grijalva? Mr. Grijalva votes no. Mr. Courtney? Mr. Courtney votes no. Ms. Fudge? Ms. Fudge votes no. Mr. Sablon? Mr. Sablon votes no. Ms. Wilson? Ms. Bonamici? Ms. Bonamici votes no. Mr. Takano? Mr. Takano votes no. Ms. Adams? Ms. Adams votes no. Mr. Desagne? Mr. Norcross? Ms. Jayapal? Ms. Jayapal votes no. Mr. Morelli? Mr. Morelli votes no. Ms. Wild? Ms. Wild votes no. Mr. Harder?
No.
Mr. Harder votes no. Mrs. McBath?
No.
Mrs. McBath votes no. Ms. Schreier? Ms. Schreier votes no. Ms. Underwood? Ms. Underwood votes no. Mrs. Hayes? Mrs. Hayes votes no. Ms. Shalala? Ms. Shalala votes no. Mr. Levin? Mr. Levin votes no. Ms. Omar? Ms. Omar votes no. Mr. Trone? Ms. Stevens? Ms. Stevens votes no. Mrs. Lee? Mrs. Lee votes no. Mrs. Strahan? Mrs. Strahan votes no. Mr. Castro? Mrs. Fox?
Aye.
Mrs. Fox votes aye. Mr. Rowe? Mr. Rowe votes aye. Mr. Thompson? Mr. Thompson votes aye. Mr. Wahlberg? Mr. Wahlberg votes aye. Mr. Guthrie? Mr. Byrne? Mr. Grothman? Ms. Stefanik? Mr. Allen? Mr. Allen votes aye. Mr. Smucker? Mr. Banks? Mr. Banks votes aye. Mr. Walker? Mr. Comer? Mr. Comer votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Fulcher? Mr. Taylor? Mr. Taylor votes aye. Mr. Watkins? Mr. Watkins votes aye. Mr. Wright? Mr. Wright votes aye. Mr. Muser? Mr. Muser votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Keller? Mr. Keller votes aye. Mr. Murphy? Mr. Murphy votes aye.
If the clerk will call the names of those who did not respond.
Ms. Wilson? Ms. Wilson votes no. Mr. DeSagne? Mr. Norcross? Mr. Norcross votes no. Mr. Trone? No. Mr. Trone votes no. Mr. Castro? Mr. Castro votes no. Mr. Guthrie? Mr. Byrne? Mr. Grothman? Ms. Stefanik? Ms. Stefanik votes aye. Mr. Smucker? Mr. Walker? Mr. Fulcher?
How is it, Janet?
Mr. Fulcher votes aye.
Clerk will report.
Mr. Chairman, on this vote, there are 17 yeas, 27 nays.
The amendment is not adopted. The question now occurs on the amendment nature of a substitute. All in favor, say aye. Aye. All opposed, no.
No.
The ayes appear to have it. The ayes have it. The amendment nature substitute is agreed to. There being no other members to speak to the bill, I now entertain a motion to report the bill from the gentlelady from Georgia.
Thank you, Mr. Chairman. I move the Committee on Education and Labor report the bill H.R. 2694 to the House of Representatives with an amendment in the nature of a substitute, and with the recommendation that the amendment be agreed to and the bill as amended do pass.
Question now occurs on reporting H.R. 2694's amendment to the House with a favorable recommendation. All in favor will say aye. Aye. All opposed, no.
No.
In the opinion of the chair, the ayes have it.
Mr. Chairman, could we have a recorded
The
vote?
recorded vote is requested. The clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mrs. Davis votes aye. Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Sablon? Mr. Sablon votes aye. Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. Norcross? Mr. Norcross votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Mr. Levin votes aye. Ms. Omar? Ms. Omar votes aye. Mr. Trone? Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Trahan? Mrs. Trahan votes aye. Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Byrne? Mr. Grothman? Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Walker? Mr. Comer? Mr. Comer votes aye. Mr. Klein? Mr. Klein votes no. Mr. Fulcher? Mr. Fulcher votes no. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes no. Mr. Wright? Mr. Wright votes no. Mr. Muser? Mr. Muser votes no. Mr. Johnson? Mr. Johnson votes aye. Mr. Keller? Mr. Johnson votes no. Mr. Keller? Mr. Keller votes no. Mr. Murphy? Mr. Murphy votes no.
Is Mr. Trone recorded?
Mr. Trone is not recorded. Mr. Trone votes aye.
Are there any members not recorded? Clerk will report.
Mr. Chairman, on this vote, there are 29 yeas, 17 nays.
The ayes have it, the motion is agreed to, and H.R. 2694 is ordered reported to the House of Representatives, and the chair notes for the record that a quorum is present. I now recognize for unanimous consent request, gentlelady from Georgia.
Thank you, Mr. Chairman. I ask unanimous consent that staff be authorized to make necessary technical and conforming changes to the bill as amended. Pursuant to House Rule 11, Clause 2L, I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views. I yield back.
Without objection, so ordered. We'll now be voting on two amendments related to H.R. 5191. The first amendment will be the amendment in nature of a substitute to the original amendment in nature of a substitute offered by the gentlelady from North Carolina, Ms. Fox. On which the noes prevailed by voice vote. The clerk will call the roll.
Chairman Scott?
No.
Chairman Scott votes no. Mrs. Davis? Mrs. Davis votes no. Mr. Grijalva? Mr. Grijalva votes no. Mr. Courtney? Mr. Courtney votes no. Ms. Fudge? Ms. Fudge votes no. Mr. Sablon? Mr. Sablon votes no. Ms. Wilson? Ms. Wilson votes no. Ms. Bonamici? Ms. Bonamici votes no. Mr. Takano? Mr. Takano votes no. Ms. Adams? Ms. Adams votes no. Mr. DeSagne? Mr. Norcross? Mr. Norcross votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Morelli? Mr. Morelli votes no. Ms. Wild? Ms. Wild votes no. Mr. Harder? Mr. Harder votes no. Mrs. McBath? Mrs. McBath votes no. Ms. Schreier? Ms. Schreier votes no. Ms. Underwood? Ms. Underwood votes no. Mrs. Hayes? Mrs. Hayes votes no. Ms. Shalala? Ms. Shalala votes no. Mr. Levin? Mr. Levin votes no. Ms. Omar? Ms. Omar votes no. Mr. Trone? Mr. Trone votes no. Ms. Stevens? Ms. Stevens votes no. Mrs. Lee? Mrs. Lee votes no. Mr. Trahan? Mrs. Trahan votes no. Mr. Castro? Mr. Castro votes no. Mrs. Fox?
Aye.
Mrs. Fox votes aye. Mr. Rowe? Mr. Rowe votes aye. Mr. Thompson? Mr. Thompson votes aye. Mr. Wahlberg? Mr. Wahlberg votes aye. Mr. Guthrie? Mr. Guthrie votes aye. Mr. Byrne? Mr. Groffman? Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes aye. Mr. Smucker? Mr. Smucker votes aye. Mr. Banks? Mr. Banks votes aye. Mr. Walker? Mr. Comer? Mr. Comer votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Fulcher? Mr. Fulcher votes aye. Mr. Taylor? Mr. Taylor votes aye. Mr. Watkins? Mr. Watkins votes aye. Mr. Wright? Mr. Wright votes aye. Mr. Muser? Mr. Muser votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Keller? Mr. Keller votes aye. Mr. Murphy? Mr. Murphy votes aye.
Is anyone not recorded? Not the clerk will report.
Mr. Chairman, on this vote, there are 19 yeas, 27 nays.
The amendment is not adopted. The question now occurs on the amendment, the original amendment, nature of a substitute offered by the chair. All in favor, say aye. Aye.
Aye.
All opposed, no.
No.
Ayes appear to have it. The ayes have it. The amendment in nature of substitute is agreed to. There being no further members wishing to speak to the bill, I now entertain a motion to report the bill and recognize the gentlelady from Washington, Ms. Jayapal.
Mr. Chairman, I move the Committee on Education and Labor report the bill H.R. 5191 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
Question now occurs on reporting H.R. 5191 is amended to the House with a favorable recommendation. All in favor will say aye. Aye. All opposed, no. Continue to the chair. The ayes have it.
Mr. Chairman,
Mr. Chairman.
could we have a
A
recorded
recorded vote
vote?
is requested. Clerk will call the roll.
Chairman Scott?
Aye.
Chairman Scott votes aye. Mrs. Davis? Mrs. Davis votes aye. Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Sablon? Mr. Sablon votes aye. Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSaulnier? Mr. Norcross? Mr. Norcross votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Morelli? Mr. Morelli votes aye. Ms. Wild? Ms. Wild votes aye. Mr. Harder? Mr. Harder votes aye. Mrs. McBath? Mrs. McBath votes aye. Ms. Schreier? Ms. Schreier votes aye. Ms. Underwood? Ms. Underwood votes aye. Mrs. Hayes? Mrs. Hayes votes aye. Ms. Shalala? Ms. Shalala votes aye. Mr. Levin? Mr. Levin votes aye. Ms. Omar? Ms. Omar votes aye. Mr. Trone? Mr. Trone votes aye. Ms. Stevens? Ms. Stevens votes aye. Mrs. Lee? Mrs. Lee votes aye. Mrs. Trahan? Mrs. Trahan votes aye. Mr. Castro? Mr. Castro votes aye. Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Byrne? Mr. Grothman? Mr. Grothman votes no. Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Banks? Mr. Banks votes no. Mr. Walker? Mr. Comer? Mr. Comer votes no. Mr. Klein? Mr. Klein votes no. Mr. Fulcher? Mr. Fulcher votes no. Mr. Taylor? Mr. Taylor votes no. Mr. Watkins? Mr. Watkins votes no. Mr. Wright? Mr. Wright votes no. Mr. Muser? Mr. Muser votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Keller? Mr. Keller votes no. Mr. Murphy? Mr. Murphy votes no.
Is anyone not recorded? Clerk will report.
Mr. Chairman, on this vote, there are 28 yeas, 19 nays.
The ayes have it, and the motion is agreed to. H.R. 5191 is ordered reported to the House of Representatives. Chair notes for the record that a quorum is present. I now recognize the gentlelady from Washington, Ms. Jayapal.
I ask unanimous consent that staff be authorized to make necessary technical and conforming changes to the bill as amended pursuant to House Rule 11, Clause 2L. I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views.
Without objection, so ordered. There being no further business before the committee, without objection, the committee stands adjourned.